Ron Poliquin, your Delaware employment attorney, DoverLawOffice.com. Coming here to answer another question regarding employment law. Our topic today is, I just filed a charge of discrimination with the Department of Labor or the Equal Employment Opportunity Commission. Now what? Okay. Prior to suing anybody, prior to even stepping to court, you have to file a regard to discrimination cases. For the most part, we're talking about Title VII is the federal statute. There's also state statutes that mirror it. We're talking about race discrimination, disability discrimination, gender discrimination, hostile work environment, anything that deals with a protected class. You're going to, prior to suing based on your employment, you got to file a charge of discrimination with the Delaware Department of Labor or the Equal Employment Opportunity Commission. Okay? And you have to do that within 300 days of the last discriminatory act. There's all sorts of caveats that I got to tell you about that. I can't explain it in a 3-minute video. You'll have to talk to an experienced employment attorney, but that's the statute of limitations. 300 days. Just think about it. Breach of contract, 3 years. Personal injury, 2 years. Now you have employment discrimination. You got 300 days. Not a long time, by the way. Okay? So there's a lot of times people come to me and it just, SOL can stand for something else rather than statute of limitations for them. Okay? So you have to jump on these issues early. You have to see an attorney early. What happens is you have to visit the Department of Labor and the EOC. They can do dual charges, meaning they can file charges in both for a federal cause of action and a state action, and either the Delaware Department of Labor Office of Anti-Discrimination or the Equal Employment Opportunity Commission. I usually go with advising my clients to file with the Delaware Department of Labor Office of Anti-Discrimination. And there's a dual charge, so you file them both. So you're covered for both the state cause of action, federal cause of action. I feel like I'm saying cause of action way too much, okay? All right, but anyways, you're being discriminated against. What you do is you call the Department of Labor Office of Anti-Discrimination. They're going to make you fill out a questionnaire, like something like this. It's going to be a bunch of pages. Based depending on what your what your claim is, whether it's racial discrimination, gender discrimination, there's different forms to fill out. So first you got to call them to set up an appointment, okay? And you got to fill out their intake sheet, and then they'll set up an appointment. Now the Department of Labor, quite frankly, is very backlogged, very understaffed, and so it's going to take some time for that to happen. You're going to want to schedule that appointment right away because that's when they can backdate the charge of discrimination. So you're going to want to, 1, call the Department of Labor, 2, fill out the intake sheet, 3, get an interview to file a charge of discrimination. Charge of discrimination is going to look like something like this. It's going to be a form. Okay? I always like to help my clients fill this charge of discrimination out because it's very important. It's going to limit later on what you can sue about or what you can file a lawsuit about. Race, color, sex, religion. You got to check the right boxes here. It's really important. And sometimes the intake worker for the Department of Labor is not going to know exactly what you're looking to do. So whether it's continuing action, and then you put jurisdiction, there's going to be brief statement allegations. I like to draft this up myself for my clients so there's no confusion later on where the defendant, because I represent workers, right, for the most part, employees, can say, well, you didn't put that in your charge of discrimination, therefore you cannot bring it up in court later on. So this is a very, very important document. It's signed under penalty of perjury, but the confusion comes when you have a client or an individual that's being discriminated against, somebody that's not sophisticated, and the Department of Labor intake worker doesn't quite know the person's story. Maybe they're not communicating it right, and they screw up the charge of discrimination, can really screw the case up. Okay? So you do the interview, then you finally get a stamped charge of discrimination. What happens after you get a filed charge of discrimination is The employer will get that charge of discrimination. They'll be invited to do is 1, 20 days to answer the charge of discrimination. A lot of times they'll ask for extensions on that. Or 2, they can seek mediation. Okay? An answer is basically saying everything, they're going to say everything in here is untrue because of this, this, and this. They're going to respond to the charge. Okay? You say you were sexually harassed by boss X. They say that's not the case. They deny it, basically. Or they have the option to be invited to mediation. Okay? One thing I will guarantee, okay, if you're a pro se litigant and you go to mediation with an employer, do not expect to get much out of an employer. Simply because there's not a lot on the line yet. There's been no lawsuit filed. And quite frankly, even if you have an attorney during that mediation, a lot of times the employer will try to lowball you, and they don't have any incentive at that point to that it's real. They haven't really lost anything. They might have paid an attorney. So the mediation, in my experience, has been of limited success, but it's always good to explore mediation and see if there's any opportunity to resolve a case early on. There's a lot of benefit to that. Okay, let's say they answer it, or you do a mediation and it wasn't successful. After that, there will be an investigation by Department of Labor. How intensive an investigation is, I don't know. You'll have to, it depends on how much interest your worker at the Department of Labor is interested in investigating the case. It depends how backlogged they are. But a lot of times, what will happen is the investigator can come to a couple findings. They can do a cause finding, which, yes, they find that there's been discrimination or there's been some kind of retaliation against the employee. They'll say, yes, we find that there has been discrimination. 2, no finding of discrimination, or they can say there's no cause, okay? So even after that, what happens after that? There's really no enforcement mechanism unless the Department of Labor takes a case, which they rarely do. But there's no, it's not, you can't take it to court and do anything with it. So it's just a determination. Maybe it puts a little pressure on the employee if there's a cause finding, but maybe it doesn't. I've seen sometimes where it doesn't. After there's a cause finding or no cause finding, or there's no decision made, you can request a right to sue letter. Okay. Now the right to sue letter is very important, because after you receive a right to sue letter, you get 90 days to file suit. All right. So if you get a right to sue letter from the Department of Labor, you also going to have to request from the EOC if you want a right to sue letter in federal court. A lot of stuff going on here. I realize it's complicated, but you got to realize if you don't take anything out of this video, the most important thing is you only have 90 days to file suit after a right to sue letter. Okay? If early on in this process you don't think that this investigation or this discrimination process this investigation by the EOC or Department of Labor is going to do you any good, you can request a right to sue letter early prior to the investigation, or you can ask them to consider it right away if the investigation is going to take more than 180 days. I believe that's the number. And almost every investigation is going to take more than 180 days. A lot of times, what I'll do in my case is request a right to sue letter right away so the case doesn't drag on. If it doesn't seem like the Department of Labor or the EOC is going to really do anything about the case, and I'll request a right to sue letter. And after you get that right to sue letter, that's when you can finally file a lawsuit in court. So just recap, got to file a charge of discrimination, Department of Labor, dual charge, Department of Labor, EOC, and you got to get a right to sue letter prior to filing a complaint in either state or federal court. And there's all sorts of nuances. Reach out to an experienced employment attorney. Stand up for your rights. I hope that helps. Thanks.